Should a judge grant an Article 17A guardianship when the primary issue for the subject is mental illness, not developmental disability? To find out, you have to read Matter of Chaim, but it's 11 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where normally I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is part of a special limited series I'm doing on cases relevant to the elder law and estate planning community. This is the case of Matter of Chaim. The citation for this case is 26 Miscellaneous 837, published by the New York Surrogates Court in 2009 on August 21st. The issue in this case is whether an Article 17A guardianship is appropriate for a person whose primary issue is mental health issues, mental illness, as opposed to developmental disability. To understand and appreciate the context of this case, to better understand where it fits and why it matters, you have to understand a little bit of background, which is that in New York, there are 2 primary schemes of guardianship. The first is Article 81, and the second is Article 17A. And in Article 81, it's for an adult who presumptively had capacity and maybe lost capacity, has diminished capacity, maybe dementia, Alzheimer's, traumatic brain injury, something like that. And you have to have a hearing to determine whether or not there are functional limitations that warrant the imposition of a guardianship and what the narrowly tailored powers would be that preserve the greatest dignity and allow the greatest amount of civil liberties to remain with the incapacitated person. The other kind of guardianship is called a 17A guardianship, and that is for a person who has developmental disabilities. 17A guardianships are for people who have developmental disabilities and they become adults, and without a 17A guardianship, their parents who have been taking care of them until they became adults would have no power to continue taking care of them. But a 17A guardianship allows primarily parents to continue taking care of the now adult who's aged out and is still developmentally disabled. And there's a lot of other differences, and that's kind of the point of this case. It discusses the differences between those 2 schemes of guardianship. What are the facts in this case? The facts are that Chaim A is the subject here. He's 21 years old at the time of this case, and his parents filed for an Article 17A guardianship, and they have a hearing about it. The evidence at the hearing shows that he functioned adequately in New York City schools until about the 5th grade, and then he was in special education. His IEPs, which were introduced in evidence at the hearing, show that he has emotional disturbance. He has an IQ, a full-scale IQ of around 59, which is just below the 1st percentile, and his cognitive functioning is in the mild mental retardation range. But the judge noted that he spoke with the subject, and he has many emotional and psychological problems primarily, which appear to have contributed to his educational issues. The judge noted he has diagnoses of impulsivity, hyperactivity, ADD, audio and visual hallucinations, self-harm behaviors, depression, anxiety, and psychosis. And the Board of Ed calls his disability emotional disturbance. The judge then goes through what I just talked about, there's 2 primary kinds of guardianships, 81 and 17A, and talks about the differences. In particular, the judge notes that a hearing has to be held in Article 81, not necessarily in a 17A. The subject can be excused from the subject's presence can be excused in a 17A, whereas it's presumptively required in Article 81. There's a court evaluator that's required in Article 81, but not in a 17A. Medical certifications are important in a 17A, but not necessarily in 81. And in Article 81 has a burden of clear and convincing evidence, whereas 17A doesn't mention what the burden is. And finally, what the judge finds most important as a difference is that in Article 81, it's narrowly tailored. There's a lot of oversight, and it can be modified either upward or downward depending on the needs of the subject. Whereas in Article 17A, once the parents basically get the 17A guardianship over the child or the child who's now an adult, that's pretty much it. There's not much oversight, and there's not much revisiting whether the powers can be reduced or narrowly tailored. And here, where it appears that the mental illness is the primary issue, and that can theoretically be addressed with medication or therapy or something else, the judge says 17A is not the best. It's not in the best interest of Chaim A in this case, and he therefore denies the application. The judge denies the application for the 17A without prejudice to commence in Article 81. So the holding in this case is that for Chaim AK, for this child, 17A is not appropriate, is not granted, because it's not narrowly tailored enough when the diagnosis, when the issue here is not developmental disability, but rather mental illness. And that's the case of Matter of Chaim. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.